You cannot understand North Carolina's history without understanding the Wilmington Riots. Wilmington was the largest city in the South, and November 10th, 1898, Charles Aycock, who would later become governor, and Fernhost Simmons orchestrated the plan for a coup d'etat led by the Red Shirts, which was a paramilitary group like the Klan. When they were through, some studies said they killed 3 to 5% of the city, burned down the black newspaper, and declared that this was the way to return government to the proper ownership of the white man. By 1902, the last African American in the Congress that was from North Carolina, but he was the last period, George White, was in essence run out of the Congress. And so you had now an all-white Congress, black voting went down to something like 0. It wasn't until the Civil Rights Movement that it began to return some, but the big return did not happen until after the Voting Rights Act in 1965. The Voting Rights Act basically came in to enforce what should already have been the law through the 15th Amendment. Now, North Carolina is curious. When the Voting Rights Act was passed, it only covered 40 counties, which meant 60 counties in North Carolina still were not covered. The Wilmington Riots was not official history. So even though the riots occurred in Wilmington, New Hanover County, Brunswick County, none of those counties were covered. None of them. And so that's always been a curious history to us of what was covered and what was not covered. Within a few years, we returned an African American to the State House, Henry Fry. He had been denied the right to vote after the Voting Rights Act and then became the first, since Reconstruction, African American to serve in the North Carolina State House. By 1990, of course it was 25 years after the signing, you get the first African American returned to the United States Congress from North Carolina, Eva Clay. And then you get Mel Watt. But think about that. Without the Voting Rights Act, none of the progress that we've seen would have happened. This is a story that's never been told. We had a great candidate in President Barack Obama. But if you go back and look in 2008, he lost on election day. He won doing the same-day registration early voting. And doing the same-day registration early voting, the Forward Together movement, the NAACP, we did something called the million-person march to the polls. And our goal was to get at least 1 million black and brown people to utilize same-day registration early voting. He won in the same-day registration early voting. He lost on election day. That's the practical impact.
I think the arc of American history has generally been that we have tried to be more inclusive when it comes to the franchise, starting with newly freed slaves, women, young people, 18-year-olds. There have been fits and starts, but generally the arc of American history has been to be more inclusive. Somehow, some way, I don't think it's a coincidence, with the election of Barack Obama in 2008, there was a concern about the Obama coalition that he had put together, a concern that there was going to be the loss of political power, and suddenly we heard this mantra about voter fraud.
There had been a number of voting changes that made access to the ballot box, more ready and easier. And so part of the idea, I think, after the Obama election was to undo all of those things that allowed people who had not been participating in elections to participate more fully. The idea was that they didn't want this outcome again, and so one of the ways to do it was literally to change the rules that govern our democracy.
So the Voting Rights Act of 1965 was a tremendous healing measure undertaken by Congress, and it was one of the few major kind of civil rights related acts that were not prompted by just a slew of courtroom decisions. This was something that largely was a substantially positive step taken by Congress to ameliorate a lot of the discrimination that you saw, especially in former states of the Confederacy, against African Americans in the voting booth. So what we had was a system of preclearance, and that was a system by which a state that wanted to change elections procedures had to first ask the Justice Department in D.C. whether that was going to comport with the Voting Rights Act provisions, particularly Section 2. And Section 2 said you couldn't make election changes that were going to affect populations that are in a protected class in a way that was going to discourage them from voting. It also meant that you couldn't draw lines in redistricting in a way that was going to dilute the vote of those in a protected class, African Americans principally in the South, but other populations in other states that were also covered jurisdictions. So a covered jurisdiction meant you had to ask permission from the Justice Department. The time that the Voting Rights Act, and particularly the pre-clearance requirement, came up before the Supreme Court just a number of years ago, the question really was, is it right to be looking at whether or not a state or a particular jurisdiction had discriminated back in the 1970s, or should we be looking at whether or not that state or covered jurisdiction has discriminated more recently? The justices decided that it was inappropriate to look so far back in the formula to determine whether or not states or covered jurisdictions would have to seek pre-approval from the Justice Department. So they struck down the requirement that a state do so based on the coverage formula that was then in place. Shelby County, in determining that the coverage formula was impermissibly a burden on the states and covered jurisdictions, ended up meaning that you no longer would have to seek that pre-approval. And if you didn't have to seek that pre-approval, the only way for a plaintiff or someone who thought that the law did in fact violate the Voting Rights Act to get redress would be for them to then sue the state. And they have done that. So it may in fact be that with Shelby County, you're going to see a whole lot more litigation around voting issues, because that is now the only way to try to enforce the Voting Rights Act provisions, specifically those in Section 2 of the Voting Rights Act. Shelby County passes at the Supreme Court level. There had been a bill changing a lot of North Carolina's election procedures that was in the works, but very quickly thereafter, within a matter of days, the bill changes, new provisions get added, it is quickly put through the legislative process and becomes law in August of 2013. The aspects of House Bill 589 have been controversial, and it has been centering principally around photo identification, the compacted early voting period, which went from 17 down to 10 days, but required the same number of hours. Interesting formula. The end of straight ticket voting. You used to be able to pull the effective lever and determine whether you were casting for all Republicans or all Democrats. You also saw the elimination of pre-registration of 16 and 17-year-olds who wouldn't be 18 by the time of the next election. And that principally took place in high schools and also in DMVs, which you would expect, because that's when people are kind of having their first DMV run through, and that's where a lot of North Carolina's voters register.